Welcome to the AILA 2020 Hot Topics panel. My name is Ben Johnson, and it is my daily honor and privilege to be AILA's Executive Director. Now, normally this Hot Topics panel is part of the annual conference plenary session, but now that the annual conference has been moved to a virtual format, we thought it would be a good idea to record this session in advance so we can highlight some of the many issues that we've all been grappling with and maybe look ahead to some of the challenges that we know are still on the horizon. Almost all of the topics that we'll highlight here today will be covered in much more detail during the virtual annual conference. That's going to be happening on July 20th to the 23rd. It's going to be an historic event. It's the first time we've ever had a virtual conference, and it's an exciting opportunity for someone who has never been to an annual conference to get a taste of what happens. Each day of the conference will focus on a different substantive practice area, and they will have concurrent tracks, one on fundamentals and one on intermediate advanced level programming. All the recordings are included in the price, so it's the best value you're going to get in terms of CLE content and access to the latest information. So if you haven't seen the program or you haven't registered to attend, you should definitely do that as soon as possible. I want to give a quick national office update, and then I want to talk a little bit about the political landscape on immigration and what to expect from a really divisive but incredibly important election season. So in terms of what's happening at the AILA National Office, I think the short answer is everything all at once. Like all of you, AILA's been hit hard by the COVID-19 pandemic. We've had to quickly figure out how to transition all of our staff into being remote workers. We've been forced to downsize our staff, and we put a freeze on any non-essential expenses. And like all of you, we're trying to figure out how do we do that while at the same time continuing to deliver the highest quality products and services. Trying to figure out how to do more with less isn't easy for anybody, but everyone here at the AILA staff is completely committed to making sure that AILA members are getting the information and resources you need to keep going strong. So in addition to pivoting quickly to create a top-notch virtual annual conference to replace the in-person conference that we had to cancel, we're also working on the new edition of Kurzban. Because it's such a critical practice resource, IRA Kurzban has decided that it needs to include all the latest information on changes related to COVID-19, all the new executive actions, all of the Supreme Court decisions that are coming down this term. So it's going to be published a little late this year, but it's going to be more up to date than it's ever been, and it's going to be the most valuable thing you have in your immigration library. We've also done things this year that we've never done before, like COVID-19 Resource Center, where it's updated daily with new information on agency closures and policy changes that are coming at us all the time. We have an entire web page dedicated to practice resources related to COVID-19 that are really valuable. It's got information on the SBA loan program, how to market your law firm during a pandemic, how to plan for reopening, lots of other really valuable practice management resources at the volume and type that we've never really done before. We know it's necessary, and we're hoping it'll continue to be of value to members as we lean into this environment. We've also been doing some amazing litigation work. Now, Marquette is going to be talking about that in the next section, but it's been a really, really effective effort. So the bottom line is that yes, times are tough, but so are we. No matter what comes at us, we're going to keep doing everything we can to get all of you the information and resources you need to keep fighting for your clients. Unfortunately, when it comes to the politics of immigration and what to expect for the rest of this year, we're going to have to be prepared. There's going to be more coming at us in the months ahead. President Trump came into office using immigration as a political weapon, and he's made it clear that he's not going to let up on that. And when he gets in political trouble, when he wants to fire up his base, he turns to immigration every time. With the highest levels of unemployment we've seen since the Great Depression, there's no doubt he's going to continue to blame immigration. He's going to use the economy as an excuse to do all kinds of changes to immigration, try to shut down immigration really entirely at this point. I think the most obvious example of that is the threat of another executive order restricting immigration. Again, Marquette is going to talk about some of the details as it relates to employment-based restrictions. But there's no question that the president and the administration is going to continue to test the limits of executive authority under Section 212F. And there's no question we're going to continue to keep our eye on that and litigate when we have to. But they're not just focused on employment-based immigration. The economy might be their reason and justification, but it's way beyond employment-based immigration. For example, they recently offered 9 of the 10 Board of Immigration Appeals judges an early retirement package. And when the judges rejected the deal, EOIR sent them a letter telling them that they had been reassigned to a new position called Immigration Appeals Judge. And that's not just a new title. This change will give the director of EOIR a lot more authority to control the docket, to manage the judge's time, enforce performance metrics. It really is another very direct attack on the independence of immigration judges and the immigration courts. We can also expect them to continue to focus on border, on asylum issues. They've recently announced a new set of very, very restrictive, punitive measures related to asylum, to deny people access to the asylum system, to eradicate and redefine this concept of persecution. So that will definitely continue as this election season moves forward. It's really, again, across the board, I think we have to be prepared for the administration to continue to use immigration to stoke fear and anger and division. And unfortunately, I don't see any relief coming from Congress. Now, because the president has become so extreme on immigration and really gone after employment-based immigration in other areas, that it could be really damaging to the ability of businesses to use immigration to rebuild their production, for the economy to rebuild. There is increasing bipartisan support for immigration reform to make sure that we still have access to workers through the immigration system that we clearly need. Easy examples: doctors, researchers, agricultural workers, other essential workers. I know Jennifer Menier is going to talk a little bit about legislation on a later panel here. I think this is a really important time to talk to members of Congress, to build relationships with members of Congress on both sides of the aisle, and to work with new allies. But I think the honest reality is that there is so much division, there's so much partisanship, that I don't see any chance of something getting passed, let alone getting signed by the president. So that really, I think, takes us to the most important point that I can make, which is that in the next 5 months, really the only things that matters is November 3rd, right? It's election day. It is impossible to overstate how important this election is to anyone who is listening to this recording. President Trump has done more damage on immigration than any president in the past 100 years. If you're wondering whether you should get involved in the election, then you should stop wondering and you should get involved. AILA has launched a political engagement effort to provide members with options on how to get involved. But one really important place to start is Immigrants List Civic Action Fund. Now, Immigrants List is a political organization. It's a C4 started by AILA members, and it's been working to educate the public on the importance of voting and on the president's record for a while. They've got a good track record. I encourage everyone to go to their website and find a way to get involved. Let me stop there and turn the camera over to Marquetta Lint for her presentation. But before I do that, I just want to say how incredibly lucky we all are to have had the benefit of Marquetta's leadership during this really difficult year. Her intellect, her passion, her calm, steady leadership were just what we needed through all of this. So Marquetta, thank you very, very much for everything you have done for AILA. We're very grateful. So take it away, Marquetta.
Thank you, Ben. It has certainly been a very busy and intense year for all of us, and it's really been my honor to work with you and the amazing staff of the National Office, the AILA committees, and the many other AILA volunteers at such an important time for our association and for our clients. So turning specifically to some of the political issues in the area of business immigration, all of us who practice in this area know that under this administration, business immigration has been under attack in ways that we've never seen before. For several years already, as business practitioners, we've been dealing with restrictive memos, restrictive adjudications, and relentless bashing of our clients in the media. And this year has been especially difficult, particularly in the last few months, as we've had to deal not just with the anti-immigrant sentiment that we've seen over the past several years, but also with an increase in intensity of the attacks on H-1Bs and other business categories, as the administration has used the pandemic and the economic fallout from the pandemic as a lever to step up its efforts to restrict access to foreign national workers. Now, we've known from the beginning of this administration that it had a number of goals on its agenda: to restrict the H-1B program, to eliminate the F1 STEM optional practical training program, to restrict the L1 intercompany transfer program, to eliminate the H-4 EAD benefit, and a particular focus on restricting the ability of companies to place foreign national workers who serve as specialized consultants or to augment their labor force for specific needs. Now, as immigration practitioners and employers, we know the need that employers have for the skills and for the diversity of experience that these workers bring, particularly those with specific skills in areas such as STEM and business and healthcare, where employers are willing to take the extra effort and expense to sponsor those workers to be able to remain competitive as a company. And those of us who work in this area also know that we need these specialized and valuable workers to be able to remain competitive as a country. The administration and the agency have been to date able to implement a number of these restrictions administratively by changing the rules through USCIS informal policies, such as eliminating deference to prior decisions and imposing stricter requirements on companies filing H-1Bs. And we've all experienced the agency changing the rules through adjudications, simply by tightening the standards, by issuing requests for evidence on H-1B cases that ask for more documentation than we've ever seen to prove that, for example, a job for a mechanical engineer or a marketing analyst actually requires a bachelor's degree. And the agency has been making these changes without an actual change in the rules, without changing the statute or the regulations, just by agency action. And given the significant impact that these changes have had, as lawyers, we know that this is impermissible overreach. And AILA and many of you have sued the agency when it has denied cases using this type of administrative overreach. And we'll talk a little bit more about that later. But for the most part, until now, the agency has not formally changed the rules, the actual standards that it uses to adjudicate business cases. But unfortunately, likely, that is about to change. Because right now, we're finding ourselves really at a unique moment in the course of a global pandemic and sudden high levels of unemployment in this country that have created a political opportunity for the administration to restrict immigration. First of all, the president has issued a series of travel bans on immigration based on his authority under INA Section 212F to restrict entry of foreign nationals into the US. And one of my colleagues will cover those in more detail later. But from what we've heard, the version of the travel ban that the president is about to issue through a presidential proclamation would, for the first time, bar the entry to the US for a temporary time for L1s, H1Bs, H2Bs, and J1 visa holders. We're expecting that, like the prior presidential travel bans, the rationale would be based not on the risk of transmission of the coronavirus, but as a response to the current rates of unemployment caused by the economic impact of the virus. And also, like the prior proclamation, we would expect that it will have exemptions for healthcare workers and others fighting COVID, for essential workers related to the agricultural supply chain, and others entering in the national interest. And that proclamation is expected to be issued any day. Now, at this moment, to some extent, a proclamation that bars the entry of foreign national workers who already can't get visas due to suspended consular operations will not have a very broad-reaching impact in the short term. But we understand that the president's hope is that the proclamation will still be in effect in October, when it would bar the entry of new H-1B holders who were approved under this year's lottery and who need to enter the US from abroad after the start of the fiscal year on October the 1st. AILA and others have been looking ahead to litigation to challenge the expected proclamation, and we will make a determination on how to best proceed once we've seen the actual language and the impact of the proclamation, so stay tuned on that. Of even more serious concern are the regulatory changes that we're expecting to see from the agency, most likely next month. These regulatory changes have been long in the making under the current administration. We've seen them on the regulatory agenda for some time at this point. But again, at this unique political moment, we have word that the agency intends to publish them in the very near future. And the expected changes sound pretty ominous. To use the regulations to rescind the F1 STEM OPT program, no longer allowing certain employers to extend the standard 1-year OPT for an additional 2 years of STEM practical training, to rescind the H-4 EADs for spouses of H-1Bs, to rescind EADs for asylees, refugees, and TPS holders. And from the perspective of a business practitioner, probably the most frightening aspect of the expected regulatory changes is an H-1B regulation, which again has been long in the works and is expected to make significant changes to the current H-1B program, including changing the definition of the H-1B specialty occupation, the regulatory 4 prongs that we've all been working so long to document in our H-1B petitions. Those would be revised to reflect a different standard, which will surely be more difficult to meet. Also, the regulation is expected to change the regulatory standards for the employer-employee relationship, which we would expect would make it more difficult for employers to place H-1B and L-1 workers at third-party sites and otherwise use employment arrangements that are commonly used in our modern workplace. Also changing the wage requirements for H-1Bs. And of course, when I say changing the wage requirements, I mean increasing the wage requirements and substantially increasing the H-1B filing fees. We initially heard rumors that the filing fees might go up to as high as $75,000 or $100,000. Those numbers have come down, but they're still quite high. The most recent number we're hearing is that the filing fee would be raised to $20,000 for an H-1B petition, which is still exorbitant and would be difficult for both large and small employers to pay for an H-1B worker, and would of course have a chilling effect on H-1B hiring, which is surely the purpose of this type of unprecedented filing fee increase. Currently, the only thing close to it is the filing fees for an EB-5 petition, which is about $3,600, and that is for wealthy people making substantial investments in the US, not for companies or organizations employing H-1B workers to serve in important roles as teachers and scientists and IT workers and healthcare workers and others. That sounds quite ominous, as I said. We're of course waiting for that regulation to be published. We've heard that the agency is looking for ways to bypass the normal notice and comment period and instead make the new regulations effective immediately as interim final rules. Now, this is a very serious procedural issue. Our system of regulatory promulgation is based on providing members of the regulated community with the opportunity to provide comment about the impact and about the legality of regulations before they're finalized. And that is why very few regulations are published as interim final rules without opportunity for comment. If it chooses to publish the regulation in this way, the agency will need to justify the just cause for publishing without notice and comment. Overall, we believe that there will be some important grounds on which to challenge the regulations I described in court, including the basis for publishing them as interim final rules without opportunity for comment if the agency decides to move forward in that manner. And both AILA as well as the business community are preparing to challenge these regulations in court if necessary. After all this gloom, I would like to end on a bright spot and one of my favorite issues to talk about, which is AILA's litigation efforts. As many of you know, AILA now has a litigation department with Director of Federal Litigation, Jesse Bless, who works with our amazing administrative litigation task force headed up by Ron Klasko and Jeff Joseph, and includes a number of other creative and citizen litigators. And the work that they are doing in coordination with the American Immigration Council and other partners has just been amazing and has been a very effective tool to push back on the overreaching action of the agency when it issues guidance without process, when it denies cases that go beyond the standards and the regulations, when it issues presidential proclamations that exceed the executive power under the statute, and in other areas. Just a few of the highlights: together with our partners, AILA has filed a class action and requested a temporary restraining order to challenge the recent immigrant ban issued by the president in April. That litigation is early in the proceedings, but has already resulted in the approvals for some of the plaintiffs. We filed a class action to challenge the presidential healthcare insurance proclamation, where the judge has certified the class and we have obtained a preliminary injunction. The litigation is ongoing on both the injunction and the underlying case, but the injunction already has resulted in many relatives and other immigrants who've been able to enter the US without being subject to the draconian provisions of the healthcare insurance proclamation. We recently filed a class action challenging denials of H-1Bs for certain type of analysts. And please note that as the case has resulted in approved petitions for our named plaintiffs, which is great, We're looking for additional plaintiffs whose H-1Bs for market research analysts were denied under the first prong of the specialty occupation rule. Within the next few weeks, we'll be filing a complaint challenging certain aspects of the public charge policy manual, challenging the additional burdens on individuals seeking to immigrate. And we're preparing a legal challenge to the USCIS proposed fee increase, which would raise fees on certain applications, including naturalization applications with unprecedented increases. And finally, we're looking at challenging the recent increase in agency rejections and denials of forms with non-material administrative errors, such as leaving blank spaces on forms for questions where there's no responsive information. And in addition to all this litigation that AILA's been doing as AILA has also supported hundreds of you as members who've been challenging and many winning USCIS denials of H-1Bs and other cases in federal court. Our litigation efforts run by Jesse and the task force, together with our partner organizations and pro bono law firms, have not only been heroic, but they've also been effective in holding back some of the most excessive agency action. And we are certain that we'll be seeing more exciting battles and wins on litigation issues critical to us in the year to come. And with that, I turn it over to Alan to cover USCIS and Department of Labor updates.
Thank you, Marquetta, for your updates. We will now discuss updates with USCIS and the Department of Labor in the new COVID-19 world. As many of you know, as of April 24th, many of the local offices were closed. Well, actually all of them were closed, and they weren't even taking emergency appointments, and they expected to be closed at least through June 4th. As of today, June 10th, some of those offices have reopened, but all of the biometric centers are still closed. As a result, they were doing no interviews for a substantial amount of time, a little bit over 2 months. So the local offices will now have to reschedule all those interviews. And if they required, a new update with the biometrics because of the timeline, then those also will have to be done again, which is going to cause a large backload at many of the offices. As well, and most importantly, the agency suspended naturalization oath ceremonies, which is a big problem, and it was covered in the news about how people weren't going to be able to vote this year because they weren't able to take their naturalization ceremonies. And so during COVID-19, at the very end, they started having isolated naturalization oath ceremonies in different locations on a small scale, 100 people or so at a time. And now you will find that many of the offices that have opened are prioritizing the naturalization applications first, which means they're doing the oath ceremonies, which is going to make all the other applications fall further and further behind. Agency also made a number of changes to H-2A and H-2B to make those applications move a little bit faster and smoother in the new COVID-19 world. So those non-citizens would continue to have work authorization to continue to keep the farming industry going and help us along the way. One of the big asks of us, of the agency, was to get automatic extension for applications to avoid sort of having a processing delay and to ensure that our clients still had status. As of this date, it was not granted, although the national emergency was declared on March 13, and the COVID-19 sort of restrictions have lasted a little bit longer than what the president initially expected. So therefore, we really haven't had a clear expectation of exactly when the offices are going to return to normal, or if they will ever return to normal. Because of COVID-19, there will no longer be these crowded waiting rooms. And so that's going to stagger the effect. So the main walk away from this is that currently there isn't an understanding that there's going to be a bailout to do auto extensions. So therefore, people who were here, that were here on the visa waiver, were granted an automatic natural 30 days. But if they actually had COVID and they were in the hospital, they might have already used those 30 days and may require something else. So that's going to require you to sort of talk to clients to make sure you understand how long they were here and what they actually had, and if you can extend their visa or not. More importantly, what you want to do is check daily, and almost every time you file an application, with the COVID resource page from AILA.org. All the information and updates are there all the time, and I'm constantly going back to that page to sort of see if something has changed. The main things to sort of check for is, as you know, USCIS waived wet signatures. So when is that going to end? It's important to sort of be apprised of these understandings so that you can make sure that you're filing your applications appropriately. In addition, USCIS has returned premium processing. And by the time you actually hear this, most everything will already be premium processed again. There's one last thing that will phase in June 22nd, and then you'll be able to sort of do that. So the important walk away from this is to sort of enhance your client communications, to let them know these are the things that you should understand about how the backlog that was already there has grown even greater, because for more than 30 days, these offices have been closed, and they're going to reopen in the same sort of restrictions as grocery stores and malls and other eating places. So you want to make sure that clients know to have this expectation that nothing's going to happen quickly, and that they may have to do some additional things because of the time of processing, and that you will keep them apprised along the way. You may also have to do some additional fees to sort of go back at your retainer and sort of say, look, this case is going to take more than what was required because there have been some changes, or you need to do something extra. And a prime example of that is, we don't know in many cases if an attorney will be allowed to actually go to those interviews anymore, just because of the spacing and the limited amount of place that is there. But keep apprised of your local office's webpage and the AILA resource page to sort of let you know what's going on. The biggest thing that's sort of happened recently is rejections. Far more important than sort of the RFEs or anything else now is sort of getting past the first stage of USCIS rejections, which means when you send an application in, if you happen to leave a box blank, for example, that isn't important, like someone's middle name, and you didn't put anything there because they don't have a middle name, and you didn't mark it NA, that during the processing from the vendor, the service may in fact reject that application and send it back to you, or even deny it. And AILA put out an excellent practice pointer for you called USCIS Rejection of Applications, Petitions Due to Blank Spaces or Other Alleged Incompleteness. It's AILA doc number 200-52238, and it's dated May 22nd. AILA is receiving number of reports about applications, about rejections, in some cases denying. And we're sort of working to put together a full picture so that we can talk to USCIS about correcting this problem, because this should not be a reason to return applications, specifically with some of the money problems that they currently have. Most of the reported rejections are on forms I-589 and on withholding of removal forms I-918. So you want to make sure when you're sort of going through those forms that first you go and look at this AILA practice advisory to make sure that you're doing the forms in completeness, because it's only going to add additional time for them to reject it and to return to you, and it may also cause some status violations. And this is also something that clients are hearing a lot about right now. So they also may look to you and say, well, why didn't you put an NA there, and sort of move forward. So a lot of what we're sort of talking about are some of the tips that are in the form to avoid rejections. And AILA recommends just doing this on all the forms that you're filing. Just don't leave any blank forms and mark NA. And there have been times in my practice where they have given an individual the middle name NA on the receipt notice, and you just call them and have them correct it, because it's better to have it receipted in than to have a problem with your application being returned or rejected to you in this sort of new COVID-19 world, specifically because there's such a slow number of people actually working in that center. And this sort of goes to the next major point that we want to talk about, which is just processing delays. We knew that applications took a long time before, and we were ordered to sort of gauge them on what the current processing times. This close to COVID-19, you will not have a clear expectation of exactly how long the cases are processing to some time outward, because the service is going to change its manpower to staff the cases that they deem important. For example, at the local offices, you will see that they've started the naturalization first. Other offices may do other things. One of the things to understand is that during this process, some candidates and some clients have gotten a benefit. I have a number of clients who had fingerprints taken from before, who were employment applications, who would have gotten an interview, who got their status granted without the interview just because of COVID-19, and they're sort of moving cases through on a vast majority of cases in that sort of way. If they had fingerprints that they could use, they would use them. In family cases, I've had it done, and also in business cases. So that's one of the great things that have sort of come on the other side of the COVID-19. But most importantly, because it's H-1B season, and we're at the very end of it, I think that it's important to talk about receipt notices and receipting things in. And AILA actually issued a practice alert about the Vermont Service Center, AILA document number 200-60436, dated June 4th, 2020. And while this is about the Vermont Service Center, this is overall, right? So the AILA UCS Vermont Service Center Liaison Committee reports to members that VSC has taken an inordinate amount of time of issuing receipt notice on profile cases, particularly H-1B cap cases, right? And from a recent SCOPS committee call, it was reported that, you know, it's even taking them long to deposit the checks and process the fee. So you can't even look to see that the check was cashed and you just don't have a receipt notice and that you sent it in. And it's very problematic because we're at the end of the filing season. So that's why it's super important to review the cases to make sure that there are no problems, no blank spaces on the form to cause that type of rejection, and to make sure that you get the fees corrected. You also want to make your clients aware that receipts are taking longer. So just because you filed it on a certain date doesn't mean that that receipt's going to follow necessarily within 14 days like it has in the past. And even from the own alert from AILA, which says an inordinate amount of time, that's not a time certain. So inordinate sounds like a month in some cases and maybe a little bit longer. And that's one of the things that AILA is following up with the service on with regards to sort of making sure that this sort of works out for everybody, that everybody has information. And so the appropriate thing to always make sure that you do is to make sure that the checks are correct, to make sure that the forms are done completely to the best of your knowledge and all the fields are completed so they will not reject it. And in some cases, it's taken as much as 6 weeks for them to cash the check. So you want to make sure your funds are there, that the client's funds are there, or whoever's issuing the check, that there's not going to be a rejection because of the processing of the fees. But the most important thing you want to do is to be able to track the record how you shipped it. So if you sent it by mail, make sure you have a receipt of when it was received and on what date it was received and who signed for it. And I would sort of add that to your system as proof of filing, because if there are any other problems that move forward, then you'll be able to say, please look for it here. And these things may change with the service, but you don't really know. Then I think the nature of where we sort of go in this workspace now is to sort of talk about RFEs and NOIDs. And most of those that I've seen in my practice have been from a client not receiving an RFE or not receiving the NOID, and then it moved to a denial without sort of knowing that. And in some ways, using my case with USCIS may help with that. But in other cases where you have applications that have been pending for 3 and 2 years for I-140s or whatever the case may be, it's a little bit difficult to sort of manage those in a sense of you're constantly checking on them. And the online service, when you put in the application, is correct. You've done the notice to the service to request an update, and you still don't sort of understand what's going on with that. This is why it's super important that you attend the conference, because we're going to have a very special session on specific RFEs and NOIDs that I can't discuss in this specific recording. In addition, you want to also watch for the increase in fees, because the final rule is moving pretty quickly, and sort of watch and take action as AILA has directed. The Department of Labor has been impacted by COVID-19, and the big picture was just the lack of funding, but they were still moving forward with processing perm applications. And during this time, you were able to sort of print the perm approval and provide it to the service until June 30th. There is my understanding that this will not be extended past June 30th. So after June 30th, you're gonna have to wait to actually get the physical approval for the perm in the mail on the certification paper and then file it. In addition, they expect to have a new Form 989 coming out sometime in mid-July. So just keep your eyes open for that and maybe speak to your clients about that. And perm, when the new forms comes out, perm is gonna move to the Black system. And so that'll be great to sort of have everything once in one place at one time to be able to sort of process and move things forward. But until perm is moved to that system, it is very important that you use the service response system from the perm to sort of use that client management system when responding to cases. We know that it's taken a long time. Perm processing is just taking longer in general if you have to just sort of do that response. And sort of talking about processing times, in order to get a prevailing wage to sort of start a perm, you're looking at about 80 days right now, which is just a long time. And we really need to work hard to sort of change that queue. As far as reviews, they're looking at cases that were filed in January 2020. The audit review is for August 2019. So that's sort of a snapshot of how the cases are sort of moving forward. If it's a reconsideration, they're looking at April 2020. And for audit review, it's taken about 302 days to sort of get that audit review. And so if you get an audit, that's super unfortunate. And as many of you know, last week, when they sort of updated the perm system, the week of June 2nd, that once they brought it back up, many people logged in and they discovered that it was empty. They couldn't find their LCAs in the system. So what we know now is that you just contact the Department of Labor. Everything should be there now, but if it's not there, please let AILA know at reports.aila, as well as sort of let the Department of Labor know. And we actually have a practice alert for that, which is AILA document number 200-60930. DOL finalized a rule with regards to BALCA cases, which allows the secretary to review BALCA cases either after the case is decided or before the case is decided. And DOL moved to this because it takes such a long time to get a BALCA decision. So this means that if you actually get a perm denial, and then you sort of appeal the case to BALCA, and there are a lot of appeals, and if the secretary wants to make a decision across the board, then the secretary is able to sort of pull that case up and make a decision even before BALCA takes a first look at it. So that's something to just be aware of, specifically in this large unemployment world where we might run into a lot of issues moving forward. So part of also the annual conference is going to be a detailed discussion of all of the new BALCA cases, which there really haven't been any that are sort of moving in a certain way for everybody in general. So there's sort of like one-off cases depending on your industry to make sure that the perms are filed appropriately. So be sure to sort of tune into that, as well as the other perm processing that we have. There's a course for the university at AILA University. And now to Prashad.
Thank you, Alan. As we are all aware, on April 22nd, President Trump issued Presidential Proclamation 10014, titled Suspension of Entry of Immigrants Who Present Risk to the United States Labor Market During the Economic Recovery Following the 2019 Novel Coronavirus Outbreak. The proclamation suspends immigration into the US until at least June 22nd for certain immigrants who the president has declared pose a risk to the US labor market as it seeks to recover from the economic downturn caused by the COVID-19 pandemic. We are days away from the expiration of this ban, and there has been no update on this, and we will continue to closely monitor the developments. On May 29th, President Trump also issued a proclamation pursuant to his presidential authority to block certain Chinese nationals associated with entities in China that implement or support China's military civil fusion strategy from using F or J visas to enter the US. The proclamation applies to graduate level and higher students and researchers from the PRC applying for visas or seeking entry to the US who receive funding from or who are currently employed by, studied at, or conduct research at or on behalf of, or have been employed by, studied at, or conducted research at on behalf of an entity in PRC that implements or supports PRC's military civil fusion strategy. More details on this proclamation and the specifics applications are listed on our website, and you can file it under AILA document number 2005-2991. Our last liaison meeting with the Department of State took place on March 5th. We have posted the meeting notes, and you can find them under AILA document number 2003-1030. State started the closure of posts and reduction in visa services due to COVID-19 on March 13. The posts are continued to be closed, and they have limited services to US citizens and visa services only on emergency basis. State advised that in order to obtain a visa under an exception, applicants will need to contact the consulate and follow the application procedure, which are expected to vary post by post. AILA Rome District Chapter and the Latin America and Caribbean Chapter have compiled a very useful spreadsheet for post-by-post information, and this helpful list is posted on AILA and can be found under AILA document number 200-31710. Plans to expand visa interview waiver program is unknown, although it will significantly help the recovery of the backlog. There is no word or any guidance on it. Process for requesting reissuance of the expired visa foil. This is a very common issue that many of our members are facing. At this time, it is not yet clear whether a request to reprint visa foil will follow the same process. State also advised to contact the visa issuing embassy or consulate for the guidance. Since each applicant has a document with a specific expiration date, for example, the medical examination, the applicants must contact the post to clarify the specific documents to be presented for reissuance of the foil. Process for requesting exception from country, region, specific health-related travel restrictions. You should contact the local post for DOS clearance. CBP will access the CCD to verify the clearance issued. NVC update. NVC is still dealing with major software problems. While the NVC continues to process the cases at this time, it asks that routine or status inquiries are made using the self-service tools available online. Due to staffing cutback to social distance, they are asking to send only urgent status inquiries, as limited staff will be unable to respond to the routine inquiries. For the inquiries received on March 27 or before, should have either received a substantive response or a notice that NVC is unable to respond to routine inquiries. Those who received this message and believe that the request pertains to an urgent medical or humanitarian situation or contain necessary case updates should resubmit the inquiry through NVC online inquiry form. And as of June 1st, NVC is responding to messages received on May 23rd. For the termination of registration issues, if you had a case close to 1-year deadline and communicated to NVC, providing evidence of an earlier message would also be taken into consideration for purpose of preventing termination of the registration. If you receive a termination notice, send the evidence as follow-up using the nvc.state.gov/inquiry. KCC remains fully operational during the pandemic. They have put in place appropriate social distancing measures and allowed contract staff to perform some functions remotely as appropriate. KCC's verification efforts continue as normal, and processing is keeping up to date with all needs to posts abroad. DOS has not yet responded to either of our 2 sets of questions that we sent since March. The biggest issue is what plans may exist for reopening posts. No word yet, but most likely an incremental process based on local conditions. State has also published Diplomacy Strong Plan that lists the guiding principles, where the department is today and where is it heading. This document shows 3-phase plan to get back to normal operation, and you can access this document through AILA Infonet. It is our understanding that each post will reopen on their own timeline based on the situation in the respective country, with approval being sought from Department of State's headquarters in Washington, D.C. The DOS committee continues to engage with the state concerning its procedure during the COVID-19 pandemic, as well as its plan to return to normal operation at its posts. Our state liaison committee is tirelessly working on obtaining additional information on important state issues, and we thank every single member of the committee for their efforts. We had our in-person AILA CBP headquarters liaison meeting back in March, right before the shelter in place. Huge kudos to our CBP liaison committee team. We had a very productive meeting with the CBP Office of Field Operations. Since the lockdown due to COVID-19, our CBP committee chair and her team have continued to the dialogue with the OFO, and in fact resolved many COVID-19 issues, related issues and inquiries. The current state of CBP affairs is mostly around satisfactory departure and various travel bans to the US. Presidential Proclamation 9984, 99, 92, 93, and 96 temporarily suspend the entry into the US of most individuals other than US citizens and LPRs who were physically present in mainland China, Iran, Ireland, and UK, or any Schengen area in the 14 days preceding their attempted entry. The most recent proclamation as of May 27 to include Brazil as well. CBP announced that any traveler with a valid ESTA who is subject to the proclamation and who attempts to travel to the US in violation of the proclamation will have their ESTA canceled, and they will not be refunded for the fees. Presidential proclamation include an exception for those who do not pose a significant threat of introducing, transmitting, or spreading the virus as determined by CDC. CBP has told us that CDC has agents stationed in different airports, and they will be making recommendations to CBP officials. Ultimately, CBP will make the determination of granting the request. JFK Port has indicated that there is no particular form to use for this request, and the request should be submitted by email, and they have actually published their emails. The request must be made at least 3 to 4 days in advance of travel unless emergency, and you can also make the request as far as 10 to 14 days in advance. If the request is granted, the CBP Regional Carrier Liaison Group will communicate with the airlines to inform them that it is acceptable to board the individual. More detailed of the procedure will be on AILA New York CBP June 1st liaison minutes. US northern and southern borders. Northern border is close to all non-essential travels. Supply chains are not impacted. Some CBP ports are processing L and TN applications that are considered essential. CBP on May 22nd issued a notice continuing to limit the travel from Canada and Mexico into US at land ports of entry to essential travels only. The restrictions will now remain in effect until 11:59 p.m. Eastern Time on June 22nd. And for more details, you can review AILA document number 2005, 2231, and 2005, 2233. Satisfactory departure requests. If an emergency prevents a traveler under the visa waiver program from departing the US within the period of authorized stay, a period of satisfactory departure may be granted not exceeding 30 days. For visa waiver program entrants who receive an initial 30-day of the satisfactory departure and are unable to leave the US, that they may receive an additional satisfactory departure period of 30 days. Both CIS and CBP have procedure in place to handle these requests. For the most part, CBP has been very accommodating to grant the first and second request. We have actually reports that the approval of the third request as well. Requests must be made at CBP port of entry or deferred inspection sites, regardless of individual's initial port of arrival. Quick update on the Trusted Traveler program. One of the questions that was addressed in the meeting that members continue to see revocations without explanation. OFO clarified that a number of factors can play into revocation of someone's eligibility. These could be a criminal record, any custom or merchandise disclosure violation, and the joke was that even an single Apple could trigger that. Or could also be even being a subject of an investigation, such as I-9 audit. For reconsideration of a revocation, the current process in place is to make a single request on the Trusted Traveler Program website dashboard. CBP needs detailed documents and honesty in response regarding the incident. It is more likely that if the incident is less than 1 year old, it may not be considered in review of the reconsideration request. OFO stated that they are working on updating the reconsideration process. They've also mentioned that although DHS Traveler Redress Inquiry Program, also known as TRIP, was not designed for this purpose, but it's possible to make a TRIP request if individual is not able to file a request for reconsideration through the CBP dashboard. Enrollment centers, effective March 20th, all enrollment centers suspended operation until at least July 6th. However, enrollment on arrival remains operational at participating airports. And of course, residents of State of New York will no longer be eligible to apply or renew membership in any Trusted Traveler program due to state legislations that restricted CBP access to the records. Couple more quick updates. CBP amended a regulation that to provide the foreign media representative from China may no longer be admitted for an indefinite period, but instead may be admitted up for 90-day period with the ability to extend the status. This rule was effective on May 8th. CBP also announced that recently opened the USMCA Center to coordinate the implementation of the US-Mexico-Canada Agreement, which enters into force on July 1st. The USMCA Center is tasked to transitioning from NAFTA to USMCA. Also, the OIG report on CBP practices is published. OIG report shows that CBP separated more asylum-seeking families at ports of entries than reported. You can access the full report on AILA document number 2006-0233. Information is rapidly changing. There are so many bits and pieces of information that is constantly coming through. Any of these may not be relevant tomorrow. We try to post as much as information that can be helpful to our members on the COVID-19 Resource Center page. I encourage everyone to visit the page frequently to get the most updated agencies and other related information. Now I turn to Kelly to cover ICE and immigration courts. Kelly?
Hello, thank you, Farshad. Per usual, ICE and EOIR are always hot topic subjects. As our organization continues to fight for fair treatment of immigrants in an independent Article 1 court, COVID-19 came in and caused even more chaos. What has become an over 1 million backlog in court cases is only now growing to be prolonged. While the nation seemed to stall trying to protect ourselves from the COVID-19 outbreak, AILA members and staff have continued to hustle to fight EOIR and ICE's poor treatment of detainees and causing unnecessary risk to our members who have been required to appear in court and at detention facilities despite COVID. AILA quickly saw the need to inform our members of updates on how to practice in these unprecedented times and developed a COVID-19 page on its website. It is updated often with important facts regarding ICE detention and EOIR practice procedures, among other important things. On March 28th, ICE announced that it would temporarily adjust its enforcement posture, stating the agency's highest priorities are to promote life-saving and public safety activities. ERO stated that they would focus enforcement on public safety risk and individuals subject to mandatory detention based on criminal grounds. The agency stated that for those individuals who do not fall into those categories, ERO would exercise discretion to delay enforcement actions until after the crisis or use alternatives to detention as appropriate. ICE stated that Homeland Security Investigations, HSI, would continue to carry out mission-critical criminal investigations and enforcement operations as determined necessary to maintain public safety and national security. Examples include investigations into child exploitation, gangs, narcotics trafficking, human smuggling, and continued participation on the Joint Terrorism Task Force. Consistent with its sensitive locations policy during the COVID-19 crisis, ICE stated that it will not carry out enforcement operations at or near healthcare facilities, such as hospitals, doctor's offices, accredited health clinics, and emergent or urgent care facilities, except in the most extraordinary of circumstances. Individuals should not avoid seeking medical care because they fear civil immigration enforcement. ICE also suspended visitations but began providing 520 minutes of free domestic and international phone or video calls at its facilities that are served by Taotong Communications. ICE began negotiating at its other facilities on 500 minutes. AILA's ICE Liaison Committee has received reports that many jurisdictions are not allowing attorneys to represent clients in person at detention facilities unless the attorneys provide and wear their own personal protective equipment. This includes gloves, N95 masks, and eye protection. This is problematic because many attorneys cannot obtain and wear the PPE that is now required because of lack of availability of equipment, health concerns, local stay-in-place orders, or for other reasons. Several AILA members, however, were able to find the equipment and courageously represented their clients. Some, including Michelle Saenz Rodriguez, even posted photos on Facebook with their blinged out PPE. The immigration courts were also severely impacted by COVID-19. All non-detained cases were postponed. In this COVID-19 era, most attorneys have been obtaining their EOIR information via Twitter. Additionally, EOIR notifies registered practitioners via email with any EOIR stakeholder updates. Also, attorneys are encouraged to consult Appendix R of the EOIR Immigration Court Practice Manual, which is now being frequently updated and contains standing orders at local courts. Individual judges at various immigration courts have further released standing orders. Some of the standing orders allow for telephonic appearance by attorneys without a motion. Others require notification to the court ahead of time, but by less formal means, including email. And many of the standing orders are concerning because they state that any party appearing telephonically waives the right to object to admissibility of any document offered in court on the sole basis that they are unable to review the document. This is problematic because it is fundamentally unfair. An attorney should consider objecting on the record to this blanket waiver of a statutory right explicitly provided at INA Section 240b-4, particularly where they were precluded from representing the clients in person based on the PPE requirements. In a public outcry for the safety of our members and court staff, AILA joined in litigation to stop in-court appearances. Immigration practitioners in the private bar were being required to appear either at the court or at the detention facility during these scary times. I personally had a detained case where I filed motions for telephonic appearances for me and my witnesses in a detained merits hearing. There was no standing order in place, so after several follow-ups with the court and no decision on the motion, the court administrator told me that I had to either appear at the court where I could be with my witnesses or the detention facility with my client. Given my fear of COVID-19 and being locked in a detention facility where I had no idea of the sanitary conditions, I chose to appear with the witnesses. When I arrived to the court 3 hours away from my office, no ICE attorney was to be found. I never received service of an ICE motion to appear telephonically, so I was quite frustrated that ICE was able to appear telephonically, but I was not. AILA was serving as a plaintiff in a detention-focused litigation, so I was able to offer up an affidavit as to my experience. The litigation asked for a temporary restraining order that would have, among other things, required EOIR to postpone all in-person detained hearings with the exception of bond hearings for the longer of the duration of the currently declared national health emergency or a relevant state emergency. The TRO would have required EOR to provide for the automatic adjournment of any scheduled hearing or any court-ordered deadline, including bond proceedings, for a period of 60 days upon submission by the detained person or the detained person's counsel of a notice. And the TRO would have required ICE to provide BTC and teleconference capabilities and to take a number of detailed and specific steps relating to counsel communications, the installation of telecommunications and BTC facilities, and the provision of PPE. Unfortunately, the judge denied the motion for a temporary restraining order. Given the denial of the TRO, the legal team made the decision to withdraw the lawsuit. AILA did not object to this course of action. AILA staff were absolute all-stars in this action. EOIR is now gradually reopening the non-detained docket in several jurisdictions. It is important to continue to consult the EOIR practice manual and stakeholder website. All right, well, I'm going to pass off to Jeremy McKinney, who will now be talking about hot Supreme Court and EOIR updates.
Thanks, Kelly. Turning now to a Supreme Court and EOIR update, I want to start this year with a case I speculated about last year because it really frames where I believe the Supreme Court is at right now. And that is the reestablishment of the judicial branch as the interpreter of federal law after too many years of deference to the executive branch. After annual conference last year, we got the Kaiser versus Wilkie opinion from the Supreme Court, a Veterans Affairs case addressing what's called our deference, the virtually unchecked deference extended to an agency's interpretation of a regulation, even when that agency interpretation was not previously published or subjected to any APA notice and comment. Through a wide-ranging set of opinions, a majority upheld our deference, but really made it toothless. In Justice Kavanaugh's words, if a reviewing court employs all of the traditional tools of construction, the court will almost always reach a conclusion about the best interpretation of the regulation at issue. After doing so, the court then will have no need to adopt or defer to an agency's contrary interpretation. This term, we got a pair of 7-2 decisions favoring judicial review. Typically, whether a finding is a question of law or fact is vitally important because the INA protects legal review of constitutional or legal questions. And at times, the INA bars or limits review of factual questions. In Guerrero-Lasprilla versus Barr, the court made clear that a question of law includes mixed questions. That is, review of the adjudicator's application of undisputed or established facts to a legal standard. In Guerrero, the legal standard was due diligence in filing an untimely motion to reopen. In Nasrallah versus Barr, the court stated both factual and legal challenges to a Convention Against Torture or CAT denial are subject to judicial review. The Supreme Court is preserving our right to judicial review, but getting into court is only half of the ballgame. We need to be vigilant when it comes to this standard of review. That is, how much scrutiny will the court apply to the agency action? Questions of law, and that includes mixed questions, are subject to de novo review. The court does not owe any deference to the agency. Conversely, factual questions are reviewed for substantial evidence, a very deferential standard of review where the agency's finding of fact are conclusive unless any reasonable adjudicator would be compelled to conclude to the contrary. Therefore, make sure mixed questions, such as whether it is more likely than not a person will be tortured in the future, is treated as a question of law and reviewed de novo. Also, question the so-called discretionary bar on judicial review. Isn't the finding of whether a person will suffer extreme hardship or exceptional and extremely unusual hardship at its core a mixed question of law and fact and not discretionary? This administration continues to push the legal envelope on every immigration front. Consequently, this Supreme Court term was one of the most busiest on immigration issues, with largely disappointing results. In a pair of orders, the usual 5-justice majority lifted first the nationwide injunction and then an injunction within the Seventh Circuit, which had stopped the public charge rule from going into effect. The second February 2020 order resulted in a blistering dissent from Justice Sotomayor. On crimmigration, the court tended to side with the government, finding in Barton versus Barr that the stop time rule is triggered upon commission of an offense listed at INA section 212A2, regardless of whether the person is actually subject to the grounds of inadmissibility. In the criminal case, Schuler versus US, Justice Ginsburg, writing for a unanimous court, concluded a serious drug offense means a state offense that involves the conduct specified in the statute, which in this case was manufacturing, distributing, and possessing with intent to manufacture a controlled substance. The state statute can be broader so long as the conviction necessarily requires the particular conduct specified in the statute. As SCOTUS blog puts it, Schuler confirms two realities of the court's docket. The first is the ease with which the court finds unanimity in ruling against criminal defendants. The second is the sprawling reach of federal criminal law, particularly with respect to drugs, guns, and immigration. The Supreme Court is also allowing state criminal law to sprawl its reach to include aspects of immigration law. In Kansas versus Garcia, the court concluded that Kansas could criminalize the use of stolen Social Security numbers to gain employment, territory historically reserved to federal law enforcement. Good news. Today, the Supreme Court, in a 5-4 decision, rejected the Trump administration's attempted termination of the DACA program. Today was an incredibly significant but narrow win for DACA recipients. It is critically important for AILA members and our clients to understand that this is not over. The Supreme Court reached two really important conclusions today. First, continuing the trend that we've seen this term, the Supreme Court concluded courts have jurisdiction to review agency action, including the attempted termination of DACA. Those opposed to DACA had argued that because DACA concerns in part a decision to remove a non-citizen, it is committed exclusively to agency discretion and is not reviewable. Chief Justice Roberts made clear DACA is about so much more than the action of deferring enforcement. Courts can review this agency action. And second, Secretary Duke's termination of DACA was arbitrary and capricious because, number one, it never addressed the component that was 100% on safe legal ground, and that is the forbearance of enforcement action, also known as the deferred action itself. The termination never even addressed it. And number two, there was no consideration of the considerable reliance interest at stake here. The court spent time talking about all of the relief and all of the dreams that have been made possible due to the DACA program. And there was no consideration of those types of reliance interests in the termination. And for those reasons, it was considered arbitrary and capricious. Now, 3 takeaways. Number one, this is an APA case and not a constitutional case. The equal protection claims lodged by the plaintiffs were rejected 8-1, with only Justice Sotomayor dissenting. Number two, the majority made clear, we do not decide whether DACA or its rescission are sound policies. They did not make a policy judgment. And number three, This now goes back to President Trump's Department of Homeland Security. President Trump can no longer blame the courts for forcing him to terminate an illegal policy. It is not illegal. If President Trump chooses now to terminate DACA, it is all on him. So we have to double our efforts to talk to our members of Congress, to talk to this administration, and tell them to not end DACA. Meanwhile, as I stated last year, the Attorney General, along with DOJ employees who were called the Board of Immigration Appeals, continue to provide good reason why there needs to be a meaningful check on administrative agencies. The Trump-possessed AG and BIA issued a mind-blowing 26 precedent decisions since the last AILA annual conference, virtually none of them with a happy ending for the foreign nationals seeking to avoid the deportation machine. The board continues to thumb its nose at the Supreme Court. The notice to appear can not only omit the time and date of hearing, but now can also omit the place. An NTA does not need to include the address of the court where DHS will file or indicate where that's at on the certificate of service. The NTA does not need to classify the respondent as an arriving alien, entrant without inspection, or admitted but deportable. This is ridiculous. 2 years ago, EOR had an opportunity to clean up its act when the Supreme Court stated in Pereira that an NTA missing a date and a time of hearing is not a notice to appear at all. But they didn't. Instead, the agency has permitted DHS to continue and even expand its sloppy practices. But the chickens may be coming home to roost. On June 8th, 2020, the Supreme Court granted cert in Nice Chavez versus Barr, a case challenging EOR's position that the government can provide the vital information in an NTA over the course of as many documents and as much time as it chooses. Stay tuned. The administration also continued its attack on those fleeing persecution and torture, straying further away from Acosta in cases like ERAL, which question whether landowners could form a particular social group. Quick pointer. Don't let the IJ apply cases like ERAL as sweeping rules. The board stated the respondent's PSG in this case was not valid based on the evidence in the record. Both the BIA and the AG sought to curtail protection under the CAT, finding the acts of rogue officers fall outside CAT protection because they are not under color of law. And most disturbingly, adding a new evidentiary requirement to a CAT claim, motivation. Per matter of RAF, to constitute torture, an act must be motivated by a purpose, such as obtaining information or confession or punishment or intimidation. An already difficult form of relief has now been rendered even more unattainable. Finally, I want to end with one trend from the Supreme Court particularly disturbing in this era of immigration and law enforcement generally on steroids: the protection of agents who violate others' constitutional rights through the doctrine of qualified immunity. In Hernandez versus Mesa, a bare 5-4 majority concluded a federal agent could not be sued in civil court over a cross-border shooting. The family's 15-year-old child playing on the Mexican side of the southern border was shot and killed by a U.S. Border Patrol agent. The agent paid no price, either in criminal court or in civil court. There should be no qualified immunity extended to any federal agent who callously strips a person of constitutional protections, including the right to simply live. But as the opinion points out, Congress is empowered to decide whether plaintiffs can seek money damages from a federal official. We need to continue to fight for our clients in courts, in the arena of public opinion, and in the voting booth. And lastly, we will hear from Jennifer.
Thank you, Jeremy. So now we're going to begin with an update on asylum applications at the border. I really wish the news were better, but it's not. So I'm just gonna hit you with the cold hard facts. The Ninth Circuit Court of Appeals did briefly block the migrant protection protocols, AKA the Remain in Mexico policy, but the appeals court later issued a new order blocking the policy in just 2 border states, California and Arizona. That order was supposed to go into effect on Thursday, March 12th, but on March 11th, the Supreme Court granted the Trump administration's application for permission to enforce the migrant protection protocols while it appeals to the Supreme Court. And then on March 20th, the Centers for Disease Control and Prevention used the COVID-19 pandemic as a pretext to issue an indefinite order blocking entry to asylum seekers at the US-Mexico border, which means effectively we have no asylum processing right now at the border. In May, the CDC decided to extend that order indefinitely. And on May 10th, the Executive Office of Immigration Review announced suspension of in-person document service and suspended hearings through June 19th, which basically ensures that asylum seekers are both missing key announcements about their cases since there's no more service, and they're being continued to forced to remain in unsafe and squalid conditions in Mexico while they await court hearings that just keep getting bumped further and further out into the future. On May 14th, AILA, the American Immigration Council, Human Rights Watch, and the law firm of Winston & Strawn filed a FOIA litigation lawsuit that seeks records and information about how the government is handling implementation of the MPP program. On May 27th, AILA joined over 200 other organizations in sending a letter to the DHS Secretary and the CDC Director, urging them to stop using COVID-19 as a pretext to deny asylum seekers their rights at the southern border. Since MPP was implemented in January 2019, almost 65,000 people have been turned back to wait for their immigration court hearings in some of the most dangerous cities in Mexico. Human Rights First has reported more than 1,000 cases of violent crimes against asylum seekers who have been forced to wait in Mexico. This policy is a clear violation of the US Constitution, of US law, human rights treaties, and just plain old human decency. The Supreme Court, of course, has yet to make a final ruling on the legality of the MPP program itself, but of course it did allow the controversial policy to continue across the entire southern border, which is not a good sign. AILA hopes that its FOIA litigation will help to shine a spotlight on this unlawful and incredibly inhumane program. And again, I wish the news were better, but that's the update of what's going on with asylum right now. And now let's take a look at what's happening on Capitol Hill. Now, I couldn't possibly tell you something about every bill that's pending on Capitol Hill, but every piece of legislation that's immigration related is being tracked by AILA, and there are summaries available on the AILA website. So if I don't cover a bill that is of particular interest to you here, you can find it on the AILA website. So the first bill that I want to talk about is the Case Backlog and Transparency Act. This was introduced in the House of Representatives in March, due in large part to AILA member advocacy. This bill calls for USCIS to be held accountable for its ever-increasing processing delays. The bill establishes new USCIS and Government Accounting Office reporting requirements concerning the status of and the contributors to USCIS's case backlog, and I think we can all guess what those are. And speaking of accountability, the need for this bill is underscored by USCIS's recent unofficial funding request for a $1.2 billion federal bailout. These emergency appropriations should not be awarded without stringent guardrails and conditions that hold the agency to account for its poor management and inefficient policies. We ask AILA members to please urge your members of Congress to ensure any funding is conditioned on that kind of increased accountability and efficiency. And here's one thing we're really excited about. AILA is working with congressional leaders to get a bill introduced this year that would create a separate Article 1 immigration court system. Our team has been working very hard on this draft legislation, and we're really hopeful that the bill will be introduced before the end of the year. Also, there are some favorable immigration provisions in the HEROES Act. This is the new omnibus COVID relief bill that passed in the House. It provides for, among other things, requiring ICE to release detainees who do not pose a threat, requiring phone and video access to counsel for detainees, making immigrant visas immediately available to physicians who are working with COVID patients, and automatically extending non-immigrant status and EADs and extending non-immigrant filing deadlines. Obviously, those would all be very welcome accommodations at this time. AILA supports those provisions, but it's unknown whether they will survive and be included in any final bill that moves forward with regard to COVID relief. I also wanted to highlight that members of Congress are beginning to act individually to demand fair and smart immigration policies in response to COVID-19. On May 27th, 9 Republican senators, wrote to the president to urge caution in making any changes to non-immigrant visa programs that could harm US businesses. This letter followed a May 21st letter that was sent to the president and the secretaries of state, labor, and homeland security, and was signed by AILA and 323 other employers and organizations, urging that no restrictions be placed on non-immigrant visas. It's worth noting that 65% of the signatories on that letter were encouraged to sign by AILA members. It was a huge effort in a very short period of time, and we're grateful to all of the AILA members that encouraged their clients to sign on to that letter. There's also a letter from June 2nd by 21 House Republicans supporting optional practical training. Another letter on May 29th, 18 senators writing to the DHS secretary to urge ICE to stop transferring detainees between facilities and to provide COVID testing at all facilities. So there's a lot of smart policy making and policy urging going on from members of Congress right now, and we are heartened to see that there are some people that are urging rational and logical responses to COVID to assist us through this crisis. And speaking of coping with COVID, AILA is more committed than ever to providing you with the tools and the resources that you need to maintain and grow both your practices and your personal wellness during this difficult time. Please be sure to check out AILA's practice success tips on our dedicated practice management page on the AILA website. And check in with AILA's Self-Care Center to find tips on everything from building your personal resilience to balancing life's demands while working from home. These resources are available to you at no additional cost as part of your AILA membership, and they're always being supplemented and updated. We certainly hope that the information that we've provided here has been useful, but we also know that new information is always breaking in immigration law. For every hot topic, there's a hotter one the next day. So we will also hold another Hot Topics panel as part of the virtual annual conference that's taking place next month. This will be hosted by Jeff Joseph, Ira Kurzban, and Gail Oshram. And it will cover breaking developments that occur between the time of this recording and the annual conference. So finally, just let me say personally and acknowledge the sad reality that these are extremely dark times for both our practices and for our clients. It seems like every bit of news these days is bad. But in every challenge, there is a seed of opportunity. And AILA is here for you as you continue to meet those challenges and to seize all the opportunities to advance justice that you can, and to protect your clients and your practices. Together, we will get through this difficult time. Together, we can make a difference. And thank you for all that you are doing, and we will see you at the annual conference.